Good afternoon. Let's go ahead and call to order the House Judiciary Committee. Chairman Willard is tied up in Ways and Means right now and hope he'll be back in a little bit, but he's asked me to go ahead and get the meeting started. If you would, please bow your heads with me and let's begin with a word of prayer. Lord, we thank you for the opportunity to come here today and do the business of this great state. We ask you to give us the wisdom that we need to carry on. Also, Lord, we recognize and thank all those that came before us that made it possible for us to be here in this free country today to exercise this democracy. Bless us and keep us. Amen. All right. Representative Dempsey, I know I saw her come in the room. She's hiding behind the pole. You want to come on up? House Bill 567. House Bill 567.
Thank you, Mr. Chairman and members of the committee. It's good to be with y'all today. This will be House Bill 567, I believe, which has one phrase added in there, which I think could be very helpful throughout our state. The proposal will clarify the law allowing DHS to bring child support enforcement contempt actions in any county in which the non-custodial parent can be found. The department deals with numerous child support enforcement cases where the absent parent has children with multiple custodial parents in different areas of the state. An absent parent is often absent in all places when we don't do that. In this instance, if the parent is not paying on one case, they are not likely paying on all cases. However, the department is limited to bringing enforcement actions in the county where the original child support order was entered, and as a result, the department must file multiple contempt actions against the same parent in multiple jurisdictions. The proposal will make it easier for the department to monitor and enforce child support orders, giving children a better chance at receiving support from both their parents. The current practice significantly burdens absent parents and can lead to inconsistent results, despite the fact that the parent's ability to pay the court-ordered obligation is still the same. The current practice also increases the burden on taxpayers, as the department has to manage several different cases in multiple offices. Experiences increased legal costs and attorneys' fees for preparing and filing multiple court actions. Clarifying the law would allow the agency to consolidate and coordinate enforcement actions when they involve the same absent parent, regardless of the county the parent lived in where the order was filed. The proposal also makes it easier for non-custodial parents to understand their child support obligations, defend themselves in court, and to direct all available resources to their children, rather than expending resources traveling to a court hearing in another county. And that is pretty much what that one little phrase will do for us. If there are any questions, I'll be glad to answer them or have some experts that are here to testify as well.
Okay, Madam Chair, thank you. Let's see if there's any questions from any members of the committee now for you. Chairman Jacob.
Thank you, and Chairman Dempsey, thank you for presenting the bill. And I follow the intent of the bill and have no problem whatsoever with its intent. But it would appear by simply adding in the language, I mean, you're enabling a contempt proceeding to be brought in the court where the original, say, child support order was issued, right?
That remains. That's where it is today,
right.
But and it would also open it up.
And then also where the person is found or where they're employed. But then there's this third set of language in here that deals with kind of in what we would call in legal parlance an in rem action where the property is located. And I guess I'm having a little difficulty wrapping my head around the idea of allowing enforcement of a contempt action against a person in a jurisdiction where there could be all the way across the state where some property is located.
Yes, and I have someone from the department that's going to help us explain that just a little bit better.
Thank you, Representative Dempsey. My name is Rachel King. I'm with the Department of Human Services. And to your point, the statute speaks to enforcement action, and contempt is not the only enforcement action that child support engages in. We have driver's license suspension. We've got the contempt action, obviously. We've got income deduction withholding. And so the parsing of those three different areas where we can engage in that enforcement action speaks mostly to the other enforcement actions that can be taken on a child support case. Contempt action in and of itself is subject to both, case law has said it's subject to the subject matter jurisdiction and the venue. You have to meet the subject matter jurisdiction and venue requirements in order to be able to hold the case. So we would, from a venue perspective, be complying with the Constitution. We're just asking for the clarification specifically so that there's no confusion in the superior courts that we can in fact contempt when we have a non-custodial parent in Rabun County, a custodial parent in Lowndes County, and an order originally filed in Cobb. We don't have to go back to Cobb to contempt on that action.
All right.
Okay. Also, I think we have a question, Representative Welch.
Following up on Representative Jacobs' question, or Chairman Jacobs' question, the contempt action is going to be against the person, correct?
Correct.
Okay.
The non-custodial parent, or the obligor.
It's going to be against the person who owes the duty of child support, correct? Okay. Well, maybe then the committee would consider, Mr. Chairman, is language that would just clarify that the contempt proceedings would be against the person owing the duty of support, and then leave the otherwise language in there so that you have the flexibility of going against the property should some other order be issued. Does it make sense? So it would be where you have by a contempt proceeding on line 9, that would be by a contempt proceeding against the person owing a duty of support or otherwise. So that way I think that addresses the clarity that Chairman Jacobs was seeking, that we're not suggesting that a court that has in rem jurisdiction against the property would also have, by virtue of being included in the statute, jurisdiction against a person who's not located within that particular jurisdiction.
I don't know the department would have any objection to that. Yeah.
Chairman Jacobs.
Or, for that matter, why don't we just, on line 12, after the word and, insert "and for in rem cases only, the court in the county where the property may be found which is subject to seizure, sale, foreclosure." I think that makes it crystal clear.
I will defer to the program as far as enforcement is concerned.
Yes. That would be.
Would that work?
Yes, it would.
Ma'am, you want to identify yourself for us? Mm-hmm.
My name is judi030915EDITED. I'm currently serving as the 40 child support director.
Okay. Thank you for being here, Dave. We appreciate you being with us. Chairman Jacobs, do you have any other questions regarding that? Representative Welch, any other questions? Any other questions from Chairwoman Dempsey, from any members of the committee? Representative Oliver.
I agree with these gentlemen here, and I just want to clarify. This would allow the department to go after a driver's license or a hunting license, or I think the professional licensures boards are in Macon, in Bibb County. But it also would allow to go against the car, the truck, the tractor. Is that your intent, Mr. Jacobs?
Right.
Okay.
Go ahead, dear.
Go ahead and say your name one more time now that you're in front of the microphone so everybody watching can also hear it.
Okay.
Mhm.
Again, my name is Tangela Gray Johnson. I'm currently serving as the child support director. I just wanted to provide some clarification to your question. The 40 agency, or the child support agency, currently has the ability to move forward with multiple administrative actions at this time. Those administrative actions includes a lot of enforcement remedies, tax off, intercept, driver's license, passport, things of that nature. However, the current issue really is around moving forward with legal action. The child support agency already has the authority to exhaust all administrative actions before we move forward with any type of legal action, which would include contempt. So a parent would need to be out of compliance with his or her order a minimum of 143 days before a case will be eligible to be placed or eligible for contempt proceedings. So currently we don't have the ability to move forward with any type of legal action that would include the contempt. We already have the authority to address all of those administrative actions.
I'm going to clarify something here as well. We can move forward with a contempt action, and we do move forward with contempt actions. It's just contempting in a county where the order is not originally issued.
Exactly.
That's really all we're trying to get to.
Exactly. So, for an example, we have at the end of state fiscal year 14, we had a little over 354,000 non-custodial parents in the state of Georgia with cases. But out of the 354,000 cases, we have 55,000 non-custodial parents that have multiple cases. So if an order is established in DeKalb County, as Rachel just mentioned, but he relocates to another county, it could be Chatham County. Currently, our judges choose not to pursue any type of legal action in Chatham County. Legal actions currently have to be sought in the county where the order was entered.
Any other questions, Representative Oliver?
No, sir. Thank you.
Okay. Any other questions from members of the committee for Chairwoman Dempsey or any of the other two witnesses, Ms. King or Ms. Johnson? Any other questions? All right. Thank you. We'll see if there's any other. Do we have anybody signed up for House Bill 567 by any chance? Okay. I know we kind of got in here late, and is there anyone there out in the audience who wished to testify regarding House Bill 567? Okay. Hearing none. Thank you, ma'am. We'll bring the bill back to the committee. Is there a motion regarding... There is a due pass motion. Is there a second? There's a second. Any discussion amongst committee members before we hear the motion?
I have an amendment, Mr. Chairman.
Chairman Jacobs.
And that would be on line 12, after the word and before the court. Insert the words for in rem proceedings only.
For in rem proceedings only.
And if Ms. Travis thinks there needs to be a comma after only, she's welcome to put that in there.
All right. Does everybody any questions regarding the proposed amendment by Chairman Jacobs? Is there a second? There's a second. Any discussion? All those in favor indicate by saying aye.
Aye.
Any opposed, same sign. The amendment is in. Any further questions or amendments to House Bill 567? Hearing none, the question is upon passage. All those in favor indicate by saying aye.
Aye.
Any opposed? House Bill 567 moves on. All righty. Okay. All right. All right. Next on our, thank you, Chairwoman Dempsey. All right. I think I also noticed after we began, I'm sorry, we have a couple of Superior Court judges here with us today. I see on the front row Judge Lawton Stevens. Judge, good to have you. You served here, Judge, when?
1987 to 1991.
And how long have you been on the bench now?
Before you were born. 24 years.
24 years. Okay, well, good. Thank you so much for coming today. We appreciate it. And I also saw in the back there Judge Roger Lane. Judge?
Yes, sir.
How are you doing today? We appreciate you coming all the way up from the coast to see us.
Appreciate y'all having me.
The robe's still fitting well? Yeah. How long have you been on the bench now, Judge?
3 years.
3 years, and you served here from 8 years?
Yeah.
8 years.
12.
Has the fog created in your brain by serving in the legislature cleared for your judicial mind yet?
Not completely.
Not completely, okay. How long did it take you, Judge Stevens?
About 23 and a half.
23 and a half years, okay, good. Well, it's very appreciative of y'all visiting with us today, and we thank you for coming. Thank you very much. All right, we'll move on to House Bill 381. Representative Welch, you want to present that bill to us?
Good afternoon, Mr. Chairman. Members of the committee, I present to you a substitute House Bill 381. This is LC 296536 ERS. You should have a copy in your folders. This is a comprehensive rewrite to our notary laws in the state of Georgia. We've nationally been looking for uniform notary laws for the various states. 5 states have adopted this uniform notary laws. Georgia would be the 6th if it does adopt it this session. The comprehensive rewrite is to allow for reciprocity between states and other nations with respect to our notarial acts, and as well as it also provides some additional protections against fraudulent transactions whereby a notary has been used to help enhance or perpetrate that fraudulent transaction by not actually sealing and certifying the notarial act. We have added we've enhanced our rules and regulations within the Act, and I'm happy to go through each of those sections with you. I'm just going to give you an overview at this point and then try to answer questions. One of the enhancements we are doing is now we will be requiring background checks of those that seek to become a licensed notary in the state. Those are on a 4-year renewal, so that will be done at that time. There's a slight increase in terms of in some of the fees that are proposed. There is an online test that will now be required for notaries, and that is the nominal fee will be charged as set by the Association of Clerks. This will be administered through them as well. In addition, we're going to allow for something for the first time, electronic notaries within the state of Georgia, so that we'll accept electronic notaries on documents, and that will be in a tamper-proof or evidence-proof seal and program on the document, on the electronic document. In addition, we're going to maintain a journal. The journal entries will be maintained for 10 years for both the written notary and the electronic notary. And you'd have to register, if you're going to use an electronic notary, you're going to have to register with the association and be certified. This is with the Commission of Georgia Superior Court Clerks Cooperative Authority, I should say authority, not association. And you'll have to register with them. You'll be a part of a database so that they can keep track of those that are actually utilizing the electronic notary, and that's for additional security. Again, you can maintain your records by a written ledger of your notarial entries if you're a notary, or you can do it by electronic format, but that also has to be in a tamper-evident electronic format, so as to preserve those records from being tampered with. That's the basic overview of the bill. If there are questions about particular sections, I will be happy to answer them.
Okay. Questions for Representative Welch from the committee? Any questions? So, Representative Welch, let me. This came through Chairman Jacobs' subcommittee. Okay, it must be perfect then, right? Okay. We have a question though, Chairman Willard.
Thank you. Tell me, Mr. Welch, we're looking at all the what is a rewrite of the notary law in Georgia, but in fact we've had the current statutory provisions of notary pretty much staying the same. Am I correct? The qualifications for notary.
We made some adjustments to qualifications. We expressly stated that you have to be a citizen of the United States, which was not provided for before, but those were just minor changes.
All right. So specifically what we're trying to do, you said, is a uniform law.
Yes, sir. That's correct.
Is this proposed by an association or the Uniform Code Commission, or where did
it is?
Originate?
Yes, sir. It was, and I don't have the acronym in front of me.
Okay.
But it was part of the Uniform Laws Commission that Edward Lindsay was a member of before.
Yes.
And that's actually where the bill came from. When Representative Lindsay was in the General Assembly, he had asked me to work on this legislation with the authority, and we have spent several summers and off sessions working with the Clerks Authority to work through this language and also to enhance some security here in the state of Georgia that's not found in the Uniform Act, but provides a little bit higher level of security for our notaries.
Thank you. One last thing. What is the specific need, if you can just address this way, what is the specific need we have in becoming uniform in this area of law?
It's allowed for reciprocity between the states notary acts so that we will recognize those other state transactions. So when we're doing interstate transactions, those notaries will be recognized here in the state of Georgia, which currently is not the case in our current law. In addition to that, allowing for an electronic stamp of a notary on a digital document, we don't allow for that on our current law either, so that would be an improvement.
And the electronic signing, is that going to entail the clerk's offices to have additional special software, hardware as a way of implementing it?
Yes, sir.
They're able to do that?
They will, but we've postponed implementation out till July of 2016, so there will be an advanced time for them to gear up for this. But I'm sure that they will be looking back to us for some additional assistance financially.
And one last question. Have we changed in this what would be the formality of signing of documents? I'm thinking of specifically deeds, security instruments.
No.
That all stays as we currently have.
That's correct. Yes, sir.
Thank you.
I will note, and I have not done the check, but we have adopted some recent laws. I think, Chairman, the one that you just sponsored that dealt with acknowledgement. I think there may be something we need to look at reconciling these two documents to make sure they're not in conflict.
Okay.
Yes, sir. That's a good point.
Any further questions for the presenter of the bill, Representative Welch? Any further questions from members of the committee? Representative Welch, so basically we are adopting a uniform act.
Yes.
That how many other states have adopted? Maybe
five.
Five so far, and it will now account for an electronic notary.
That's
signature.
correct.
Is that right?
That's correct.
And that'll be done through the clerk's authority, not through each local clerk's office, but through the clerk's authority.
Well, they'll register with the clerk's authority so that we know who is basically being given permission to do that electronic notary.
Versus where I register at my clerk of court at my courthouse now.
It's bifurcated. If you want to do electronic, you're going to register through the authority. If you're just doing your standards sign and seal, that would be locally.
So really nothing about the current law as far as notaries are concerned other than electronic, and the citizenship you mentioned will really be affected by this?
We're mandating the maintaining the journal for 10 years. We do have a slight additional requirements of qualifications. There's some slight changes to it, but overall, no, it's
so in other words, now when I notarize a document, I need to note that in a journal and maintain that for 10 years.
That's correct.
Notary. Okay.
Yes.
Okay. All right. And that's part of the Uniform Act. That's part of the Uniform Act.
It is.
Okay.
Yes, sir.
Okay. All right. Representative Welch, we appreciate that. Do you have anybody else you want to bring up at this time?
Mike Holman's here representing the authority. If he would like to speak, I'm sure he can shed a little bit more light on at least light as to how much we've been working on it. So,
okay, Mike, you want to come on forward, and the camera's on today. So,
and Mr. Chairman, we also made just a few changes that the clerks. That's why you have a substitute. Is that the clerks had a few changes they needed made to the bill. We made those in subcommittee for you today.
Okay, thank you, Representative Welch. Mike, please come forward and introduce yourself.
Mr. Chairman, members of the committee, I am Mike Holloman, and I do represent the Superior Court Clerks of the state of Georgia. Representative Welch did an excellent job. We have been working literally on this bill for 2+ years. He's been very responsive to everything that we've required, and I want to say that I think generally the bill is outstanding, and I can't impress upon you enough that an e-notary is a very critical feature to add because, believe it or not, Georgia's courts are hurtling towards e-records, and it will be here before you know it, and we really almost have to have some methodology, especially in the real estate side of our shop, because we're already e-filing real estate. We've begun e-filing civil. It's important to have e-notary in place.
Okay.
That's
okay.
all.
Any questions from the committee for Mike Holloman? All right, no questions. Okay. Do we have anybody sign up? Okay. All right. Anyone else here today to testify regarding House Bill 381? All righty. Thank you, Representative. We'll bring the bill back to the committee now. Is there any further questions of Representative Welch before we ask for a motion? Hearing none, is there a motion regarding House Bill 381?
Do pass.
There is a motion do pass in a second. Any discussion about that motion? Hearing none. All those in favor of the motion do pass, please indicate by saying aye.
Aye.
Any opposed, same sign. House Bill 381 moves on the rules. Okay, the last bill on our agenda today for full committee is House Bill 354. We will hold House Bill 354 today, so I believe, and Ms. Womack, correct me if I'm wrong, that is the last bill on full committee? I will tell members of the committee, let you know that the chairman, I was going to ask him before he stepped out, he's having to handle another bill in Ways and Means, but the chairman did indicate to me he is thinking about, and I think he may be planning on having a meeting tomorrow, having a full Judiciary Committee meeting tomorrow. So just put you on notice for that to watch your emails. But I did not get a chance, so he walked out to confirm that, but he did tell me that earlier. What we're going to do now is move to the Fleming Subcommittee. We have several bills on there, so we're going to adjourn the full committee meeting and move to subcommittee in about 3 or 4 minutes. Thank you all for being here today.